Hi, this is Kosowkowski for AP Gov, and in this video we're going to be looking at Wisconsin v. Yoder, a case that goes back to 1972 involving the First Amendment, specifically about the Free Exercise Clause. So a little bit of background about this, as you hopefully already know about the First Amendment, that one of the five freedoms contained in the First Amendment concerns the right of people to practice their religion freely. And of course, there have been many cases about this. However, the scope in this case is going to be involving the Amish and Mennonite community, which is going to argue that compulsory education past 14 violates one of the religious tenets in their community. Because within the Amish community, one of the big things that they're going to be stressing is self-sufficiency, living a simple life, and going beyond an 8th grade education would essentially endanger the salvation of not only the parents, but also the children. And this is one of the main beliefs that the Amish held. Now, at this time, Wisconsin raised their age limit with respect to formal education to 16 years. That was the requirement, that you had to be at least 16. At that point, you could drop out if you wanted to, but up until this point, you had to remain in school. So this creates a conflict between the state and the Amish and Mennonite community. Now, in particular, where this name comes about, Yoder, Frida Yoder stopped formal education at 8th grade along with two other Amish students. And of course, as I said before, that the Amish are going to be very adamant that any formal education beyond the 8th grade would certainly endanger their children's salvation, as well as endanger the greater Amish community. Now, of course, the Amish parents are going to be taken to court. They're going to be convicted of truancy when your child does not go to school. You can be convicted of that. So they certainly were, and they were actually ordered to pay a $5 fine. And of course, this is going to work its way through the court system. And the state of Wisconsin is going to argue, well, it's in the best interest of the state to promote a compulsory education. You want to live in a society where people are at least educated. And in this case, they believe that the state requirement also extended to those students in the Amish community. Of course, this is going to work its way up to the Supreme Court, and there's going to be a unanimous decision in favor of the Yoder and the two students. So this is a big victory for the Amish community. And what's going to be argued by the Supreme Court is that the Amish's practices overrode Wisconsin's law of compulsory education as per the Free Exercise Clause of the First Amendment. So when you look at the First Amendment, one of the things that they're going to be that it states is that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. That is what we call the Free Exercise Clause right here, free exercise. So the idea that you should be free to practice your religion without the state basically interfering with that. Now, there are, of course, limitations. For example, if your religion said, well, part of our religious tenet is to murder people, well, certainly that would be a reasonable restriction. And again, this is not an absolute thing, but in the case of the Amish community, it was a legitimate belief and tenet that after 8th grade, that the children should be remaining in the Amish community, that they don't need formal education, that their simple life was enough, and that their culture was enough of an education in terms of their daily practice. And the Supreme Court justices are also going to argue that, well, there is strong evidence, by the Amish to show that this law certainly would interfere with their legitimate religious practices and beliefs. And the idea that giving them an additional 2 years would be beneficial, really there wasn't enough evidence on the state's part to really show that. So at the end of the day, this is a big victory for the Free Exercise Clause in the sense that, well, you cannot compel Amish students to attend school past the 8th grade, as this is a direct violation of the Free Exercise Clause. And again, the big takeaway that the College Board and the AP Gov people want you to know is that there are provisions of the U.S. Constitution's Bill of Rights, in this case, the Free Exercise Clause, that are currently and continuously being interpreted to balance the power of the government, in this case, to compel you to go to school, versus the civil liberties of the individuals. And again, just to stress this, you can't just make up any religion and say, oh, this violates my religious beliefs. Certainly, the Amish practices predate at least 300 years, so there was a lot of evidence to show in that case that it would legitimately interfere with their faith.